In addition to the earlier concerns with the authorization section, I think there are some changes that should be made in the other areas of this home occupation ordinance, specifically in the area of use limitations that apply to all home occupations, section 74-469. Item 3, which deals with the floor area percentage, I think we need to add an exclusion that indicates that we're not counting in that 20% the garage or unimproved basement space. So the item 3 should read no more than 20% of the floor area excluding garage or unimproved basement space of a dwelling unit shall be devoted to a home occupation. The reason for that is the unfinished space that's not habitable space really I don't think was the intent to be included on an equal basis with usage of living space. I believe the 20% of the floor area is intended to apply to the living space, so I think we should be clear. And people use their garages and their basements for hobbies and other kinds of things, so I think that just should be left out of this calculation of floor space used for the home occupation. Also, I have a concern about item 8, which in the current draft says vehicles may have a total of 3 signs, 1 sign on the rear and 1 sign on each side of the vehicle. Each individual sign shall be no larger than 6 feet. I have several concerns with this. Number one, I believe that restricting signs for residents who are self-employed, while residents who may be driving a similar vehicle that's owned by their company that they're an employee for and drive home at night, which are not limited in their signage, is an unfair disadvantage that we are putting on our residents who happen to be business owners. I believe that that this new size restrictions on signage was not in the current ordinance that is in force, and so we're adding something here that I believe is a bad idea. A 3-foot by 6-foot sign is a very small sign. If you have a cargo van, that is not a very big sign. And again, I don't think it's right to limit a resident who happens to have to get a home occupation license to something that other residents are not limited to. And so I think we need to take this one out. Now, looking at the specific Type 1 home occupation use limitations, I also have a problem with the direction, the general approach that we're taking to a zoning problem. As has been discussed, the primary concern is traffic and on-street parking, which we are prohibiting with the Type 1 home occupation. We are requiring that they obtain that they provide off-street parking for any customers or employees, and that makes sense. We're dealing there with when we're talking about parking, we're talking about vehicles, and we're talking about traffic, we're talking about vehicles, but we're using the number of persons when we're down here in the use limitations, and I think that that's the wrong way to go. I think that we should be regulating the number of persons based on the number of vehicles that can be parked off street on the property, and that can vary by property. So if you've got 1 parking space, and you got one vehicle, um, whoever can arrive in that one vehicle are the number of people that can be there at any given time. So I think we need to change this to focus on the number of vehicles and the parking rather than the number of persons present. So item 2, I would change, instead of only 10 customers may visit the dwelling unit in a day, I would change that to only 10 customer vehicles may visit the dwelling unit in a day. Item 3, I also think we need to add, except for the group gatherings at the beginning, so that that's clear. The old, or the Planning Commission draft says no more than 3 customers can be present at the dwelling unit at the same time. That's the wrong way to regulate this, and it's also arbitrary. It's also too few people, in my opinion. I think that there are a lot of situations where you may have a reasonable use would allow there to be more than 3 people inside the house at the dwelling at a time. And the relevant issue again is parking. So we're assuming here, I suppose, that each person's going to come in their own vehicle. That may not be the case. You can have 3 people arrive in one car. And so I think we need to change item 3 to read, except for group gatherings envisioned in section 74-471, item 4, no more customers can be present at the dwelling unit at the same time than can arrive at the residence in vehicles for which off-street parking is prohibited or provided. Essentially, if there's parking, they can be at the house. If there's parking off-street, they can be at the house. And there's not a specific number of people that are prohibited from being inside the house, because inside the house there's not any zoning concern. They're just people in the house. Like, you can have visitors for a party. You can have as a non-commercial situation. You can. It's appropriate to regulate this based on the parking and the vehicles, not on the number of people. And while we're at it, in the section that discusses the actual application for a type 1 home occupation permit, we have a similar language relating to the parking, but then we also talk about the number of people. And I think that needs to be made consistent with the number of vehicles, just like the use limitation concern I raised a moment ago. The relevant language is except as provided for in section 74-471-4, at no time shall the number of customers and employee in the residence exceed the number of, and it did say, parking spaces dedicated for customer and employee parking. So we're basically making some sort of a one-to-one distinction that there's one person per parking space, but we are trying to tie it to parking, which I think is the right thing to do. But I think we're tying the wrong thing. So I would change it to, except as provided for in section 74-471-4, at no time shall the number of customers and employee in the residence exceed the number of people that can be reasonably transported to and from the residence by vehicles that can be simultaneously parked in the parking spaces dedicated for customer and employee parking. Basically, You have a number of people that can be arrive and depart with the off-street parking that is available, and that is an appropriate way to regulate, I believe, the concern, the zoning concern. The last two areas that I want to discuss in the ordinance, one of them involves the self-certification that was discussed on the PowerPoint presentation about the proposed ordinance change. I raised a concern that self-certification was not sufficiently discussed in the ordinance itself, and I think we should change that. When I asked the question of the community development directors, he stated that the section 74-470, paragraph C, item 1, which reads, assurance that they comply, I'll back up. The preamble to that is, the persons applying for a type 1 home occupation shall provide the following information at the time of their application. Number 1, assurance that they will comply with the standards contained in this article. And that's it. I believe that we need to be more clear that this is a self-certification, and we need to also be we need to also state that will be the basis upon which they will be deemed to have be in compliance with the use limitations and restrictions by their initialing the items. So I would add the language, such assurance will be deemed to have been satisfied by applicant by initialing next to each enumerated restriction and use limitation listed on the city's standard accessory use type 1 home occupation application as provided by the city council. I think we need to develop a form, which I'm calling the standard accessory use type 1 home occupation application. We have a home office application form currently. This would be similar to that, and I also think it should be approved by the city council. The current home office application has a couple of typos in it, and sometimes the language doesn't match up exactly with the ordinance perfectly. I think we just need to look at that. But I think that it's important that we add, as I said, such assurance will be deemed to have been satisfied by the applicant's action of initialing, so that it's clear that there's not going to be a home inspection required to satisfy the compliance with the use limitations in advance. And then further on down in the same section of the type 1 home occupation application, paragraph D, it says, within 15 business days of receipt of a complete permit application, the zoning administrator will provide a written decision to the applicant regarding their application. And that's where the current Planning Commission draft ends. I believe that we should also provide guidance as to the specific reasons that a decision of non-approval is made if such a determination has been made. So I would add to the end of that language, and shall provide all specific reasons for a decision of non-approval, comma, if such a determination has been made. The resident needs to understand why they've been denied, and the zoning administrator needs to be able to establish specifically what those reasons are, so that there is a record, because we are dealing with potentially someone's income, and the reasoning needs to be justified. So it needs to be written down. And those are the major changes that I think we should be making. And I think we'll have a really good ordinance if we do that.